Okay, what's the preliminary matter that the court can weigh in on?
It's generated by contact late yesterday from the clerk's office. While the issues concerning the documents produced from Mr. Eyman's computer has been pending in the protective order issue, the parties have been filing matters under seal until the court could adjudicate some of these issues. We were contacted by the clerk's office that said that they wouldn't maintain them that way without an order from you. So I prepared an order just to, while this matter is pending, that these would be filed under seal. Mr. Hensford has reviewed it and doesn't have any objection to that.
I'll sign that order.
Yes, sir. We weren't privy to the call that Ms. Dalton's taking the initiative and listed the pleadings at issue, and we do believe they should be under seal as well.
These are the state's filings. And they did not receive a contact. I don't know if they will be receiving a contact.
Okay.
But if we needed to add Ms. Olson's declaration that came with the latest pleading, we probably should do that, because one of her attachments, Exhibit F, is from those materials, and I believe she intended them to be filed under seal also.
They were part and parcel, so
Yes.
if they're all going to not be, then yeah, I would ask for that.
Just want to add that.
Yeah, I'll delineate that and we'll present.
Okay. The court will sign an agreed order authorizing and requiring certain pleadings to be filed under seal. The court is confident the parties can agree with respect to those pleadings, and I'll sign either this morning or ex parte, and if there is a continuing need for entry of an order, the court will sign such an order or orders upon presentation ex parte.
Thank you, Ron, that'll be very helpful. Do you have anything? Yeah.
So the court understands, and please correct me if I'm wrong, that there are two motions before the court this morning. The document indicates three, but I could only locate two.
I think there's three. There's
Okay.
two set over from our previous hearing and then a new one.
It is, Your Honor. It's that one that I asked to kind of put together. So the issue, the broader of the issues is the one that you're looking at, but there is another motion that was attended to it. So they're kind of the same, but they weren't filed the same.
Okay. So what's the first issue, Ms. Dawn? Well, it's Mr. Hensrud. These are
Right there.
Yeah. Go ahead.
Sure. I'll start with the easier one then, Your Honor.
Okay.
Again, Greg Hensrud, Kleinman's PC, agreeing for the Eyman defendants. The easier of the two motions, in my view, is a motion with respect to the Karen Eyman deposition.
Okay.
I think the issues there are pretty simple as well. We've got an RCW that says a spouse can't be examined without the consent of the other spouse. We've got CR 30, which says a deposition is an examination. So we filed a motion to quash on that basis, which we thought was fairly straightforward. The policy ramifications are in the cases. I won't tell the court about those because I'm sure the court is well aware of why the testimony of privilege is put in effect. Unfortunately, however, it looks like entirely based on a quote in the Burden case, the special master determined that she could be examined because depositions are not subject to testimony of privilege, which is clearly inaccurate. And not only
my concern with respect to the Burden case, I apologize for interrupting, and I'll invite Ms. Dalton or whoever intends, Mr. Seif or Mr. Newman, to respond to this as well. But my concern with respect to that case is that the out-of-court declarations made to a third party were declarations that the spouse made to a retailer, friends, law enforcement, and those were clearly out-of-court statements made by the spouse. Here, the distinction is that these are statements made in the form of, or potential statements made in the form of deposition, which is, of course, discovery. But I apologize for the interruption. Please continue.
Yeah, Your Honor, and I think you've started down the road of what that is. So the Burden case, as you point out, is whether or not you can depose and then have at trial third parties to whom the spouse has voluntarily said things. And the court said, you know, in that case, they're saying, can we call this third party at trial? And they said, no, you can't because it's testimonial privilege. And the court said, that's not the way the testimonial protects the in-court statements of spouses. And so they're taking that to say, oh, what they're holding there is in court. But that wasn't what was before the court, and that wasn't the issue in front of the court. The court never addressed that issue, the court never discussed that issue, it's nowhere in there. That is entirely about whether third parties can be called. So there's no authority in front of this court, and no authority I've found in the state of Washington that says that it doesn't apply to depositions. We're just asking for the common sense, for the policy reasons, the exact same policy reasons apply for testifying against the spouse in a deposition as they do in trial. And I think more fundamentally, it's just a pure statutory reading. It says you cannot be examined. A deposition is clearly an examination in the context of the RCWs and the rules. So for policy reasons, I don't even think you need to get there. If you just read the RCW and you read CR 30, clearly Ms. Eyman can't be deposed at all. And that's the only issue that we're addressing in this particular one, because Mr. Eyman, as her spouse, has claimed the testimonial privilege, which precludes her from testifying against him. They're very clear that what they want is testimony against him, so here we are.
Well, I'm not so confident that what the state wants is limited to evidence against, or potential evidence or potential statements against the interest of Ms. Eyman's husband. As the court understands, at least one of the arguments from the state in seeking to depose Ms. Eyman with respect to interactions with the other defendants. And I understand the counter argument would be, well, then by implication or by inference, those might be considered as statements against her spouse. What are your thoughts on that?
Yeah, not even inference, Your Honor, because it's the same transaction, right?
Well, I don't know about that, but
yeah, I mean, if there's another one that involves just them, I'd be interested to know. Not of which I'm aware, but I mean, if you literally are saying, you know, I'm going to ask him if he paid Tim Eyman, and then I'm just going to use that against him when he says he paid Tim Eyman. I mean, it's
well, one of the
nonsensical.
allegations is they paid her, sent her a check.
Right. But
How would that implicate Mr. Eyman?
well, I don't want to go too far down that road given the Fifth Amendment issues, but obviously, if part of that issue is part and parcel of, let me do it this way, because they put it in their pleadings, I'll just use their arguments.
Okay.
Their arguments are that those were then sent to Ms. Eyman and the children because they reached the gift tax cap for numbers to Mr. Eyman. So in other words, that, and so I can't take it a lot further than that, Your Honor, but
Understood.
if that's the context, then it's all part and parcel of the same thing. I'd also point out, nobody's saying that Ms. Eyman, she's not a defendant in the case, and nobody's saying that she had any of those issues, or even that she knew about them. That's entirely separate, and I think should never even be deposed. So on that particular issue, Your Honor, I think the simple answer is you cannot extricate testimony as from one to the other. It could be just like two people were at the scene of a murder, and you say, let's have the wife say, you know, who was there and what she saw. You know, you can't extricate the two, and it's actually even worse than that, because in this case it's an exchange between two people, or alleged to be, both of which were there. So I think you couldn't meaningfully draw that difference, and if the court was to say that, you know, testimonial privilege applies, she can only be asked questions about them that don't implicate him. I don't even know how that would look, because I don't think it's possible, but I don't think, even if we're going to say that's a legitimate interpretation of the law, it's not possible in the context of the facts of this case, in our view.
Okay, thanks. Mr. Newman, good morning.
Good morning, Your Honor. Eric Newman from the state. Your Honor, I want you to imagine a situation where Farmer Jane wakes up in the morning, she goes outside, and her prized oak tree is gone. And where it was, there's a fresh stump. And a few yards away are two married couples, Mr. and Mrs. Johnson and Mr. and Mrs. Smith. They're sitting on a cord of fresh cut wood, covered in sawdust, saws at their feet. So Farmer Jane brings a timber trespass claim against all four of them because she thinks they cut down her tree. If the defendant's interpretation of the statute is correct, then Farmer Jane cannot ask any of them if they did it. In fact, she cannot send them any discovery at all. Because if Mr. Johnson is asked, Mr. Johnson, did you cut down that tree? He could say, I can't tell you because it might implicate my wife. They can't say, Mr. Johnson, did Mr. Smith cut down that tree? I can't tell you because it might implicate my wife. No depositions at all. But it goes farther than that because they have taken the position, and you'll hear more about it in their Fifth Amendment assertions, that both interrogatories and requests for production are also testimonial. And so in this scenario, Farmer Jane could not even send interrogatories or request for production to any of the parties, because all of them could say it might implicate my spouse, even if I'm talking about my own behavior or the behavior of somebody wholly separate. So in that situation, if we take their interpretation, then no discovery can be done at all. I want you to think back over your career and how many thousands of captions in civil cases you've looked at, and how many thousands of times it was Smith versus John and Jane Doe and the marital community comprised thereof. I am sure you have seen that 1,000 times. And often it is, John Doe got in a car accident, they sue John and Jane Doe and their marital community. If their interpretation is to be believed, then both spouses are parties, then you can't send them any discovery at all. You can't depose the driver in that car accident, you can't depose his wife, you can't send interrogatories or request production, because they say under no circumstances, good or bad, can you force somebody to give testimony that might implicate their spouse in anything at all. That's their position. And that can't be the law. That can't be the situation. The reason why there is no case law specifically on this is because nobody has ever taken it this far before. But they say that this Burton case is the only one. It's not the only one. The Burton case is from a long line of cases, and over, the courts have said it only applies to in-court testimony. Burton said it, the Bonaparte case said it, and they talk about this marital bliss, like you're maintaining marital bliss. In all of these cases, the wives sent their husbands to prison. We're not talking about, oh, I had to pay a car accident judgment. The husbands went to prison over it. In the Burton case, a police officer came to the wife, said, where's your husband? She said, he's in California going to get some drugs to sell. The police officer used that statement to come in and get probable cause to arrest him. So what they avoided was having the wife come in and say to the judge, yeah, my husband's down in California picking up drugs, by using a third-party intermediary, the police officer. But it was still her testimony. The police officer had no personal knowledge. It was 100% the wife, and the husband couldn't say, you can't just go ask my wife and then offer that. And the court said, yes, we can. We're just not going to put the wife on the stand in front of a jury, which they talk about, I think, I don't want to get it completely wrong, but I think it was the State v. Clevenger case, 69 Washington 2nd, 136. I think it was that one where the court actually talked about how uncomfortable that situation is to have the wife on the stand, the husband's here, and there's 12 jurors. So they talk about that a little bit, that that's the problem that the statute's meant to deal with. But there are 4 cases, the Burton case, the Bonaparte case, State v. Osborne, which is 18 Winnap 318, that says the privilege, however, applies when the testimony of the spouse is offered at a trial or hearing. Over and over they have said that. The Clevenger case says the same thing. They use those exact words, offered at a trial or hearing. So we'll cross that bridge when we come to it. But here we've got a deposition. We want to ask questions of a witness about what she did and the interaction she had with other people. And they're saying, anything good or bad, Mr. Eyman can stop. You can't send interrogatories, you can't send requests for production. In fact, if we had sued Mrs. Eyman, if we had known from the beginning that she was involved and had sued her from the beginning, their position would be, you can't send us any discovery at all because they would implicate each other.
What about the Fifth Amendment implications that may be overriding all of this discovery?
Yeah, that is a big issue, and you're going to hear more about it in the future. I'll give you a little crystal ball. You're going to hear more about it in the future. But you'll see, and you're going to hear from Ms. Dalton, this web of privileges that they have built up. So they had Mr. Lamb represent everybody involved so that any communications between them, through him or with him, that's all attorney-client privilege. Then we had this First Amendment associational privilege that they're asserting, and the Fifth Amendment privilege that they're asserting, and now the spousal privilege that they're asserting. Over and over, they come up with new ways to hide from you, to hide from 12 jurors, to hide from the state, the truth. Over and over. And this is not just an accusation. You have found that they are intentionally withholding information because they've been in contempt since February. This is just a piece of this web. And it's got to stop. The state has to be able to ask questions. The state has to be able to investigate this claim. And piling on privileges so that we can't talk to anybody at all is not what this statute was designed for. One more thing, and I think it bears noting, there is no evidence before this court that the Eymans are married. This was brought up previously to the special master, and they tried to fix it by offering their marriage certificate. What their marriage certificate says is, at one time they were married. And this seems like a trifling thing. It seems like we're just wasting time on it, but it is not a waste of time. Over and over, they had this web of privileges where they don't want to testify, but when they need testimony, they just have their lawyers say it in a briefing with no support. The state can't allow that to keep happening, and so the state is taking the position, and it is undisputable, there is no evidence that the Eymans are currently married.
So what evidence was provided to the state that at some point the Eymans were married?
Well, I think you have, when we pointed this problem out, they offered the marriage certificate. So what a marriage certificate says is, you got married on this day, but it doesn't mean that they are still married, and the privilege only applies to a current marriage.
And what documentation would the state seek to verify that they are currently?
A declaration from one or the other that says they're currently married.
Okay.
I don't want you to rule on that reason alone, because I think the issues are more important. That is probably very easily fixable, but it is not fixed right now, and the state, we are in a bad position because this happens a lot, and we're kind of drawing the line.
Understood. Okay, thanks. Mr. Hensher?
Thank you. The good news for the farmer is that she has all the evidence he articulated, so she's going to win anyway because they can't testify. So, which talks about the sawdust and the cord of wood and the down tree, the preponderance of evidence, and she wins. So I guess we don't have to worry a lot about that. We also don't have to worry about what didn't happen. Mr. Eyman's answered interrogatories. No interrogatories were sent to his wife, Karen Eyman. He's answered interrogatories. None of them said the spousal privilege. Remember, the testimonial privilege would be something that Karen Eyman would assert to preclude Tim Eyman from doing something that would implicate her. She's not even addressed here. So Tim Eyman's just answering his own interrogatories as he has the whole time. It's talking about things that theoretically could happen, none of which have any basis in reality. What does have a basis in reality is they're asking to depose Karen Eyman. There's no case that says that. The only case that was put in front of this court is the Burden case, which clearly doesn't say that. The three cases that he added before, that are articulated before, do not deal with this issue. And I think it's very obvious why. I mean, in fact, the Barbie case that we cite, they go all about how testifying in a deposition didn't waive the spousal privilege. Why would they ever undertake that analysis if depositions were part of it and didn't waive the testimonial privilege? It would be a one-line opinion by the Court of Appeal. It would say, they testified in a deposition. Of course, spousal privilege doesn't apply to deposition, period. But they didn't. Why? Because it obviously does. So they had to look at the actual waiver issues, and that's what Barbie did. I've rarely been in front of a court with something so easy where it says you may not examine, and a deposition in its code is an examination. I mean, it's really that simple. It really is. The married part I've also never seen that. If they did want a declaration that they're currently married, great. I mean, we gave them a marriage certificate to show, because obviously they don't believe what Mr. Eyman says, so we thought, here's a public record showing they're married. They are. We could get that declaration before we did it if we want to. It's completely meaningless. What we're talking about is policy issues. What we're talking about is what the statute says, and the statute says that. And I'll also note, we do have evidence that there's a marriage certificate, so unless the state has evidence that they've been divorced since, or that they're no longer married, which would also be public record, which they don't assert here today, the state of the evidence is that they are married. They could say, theoretically, they could not get married, great, but they don't have that evidence in front of anyone. And I think we all know it's not true, so we're wasting a lot of time on nothing. The issue before the court, Your Honor, is what's the RCW say? What is a deposition? And is there any case that would lead you to believe that the clear definition of those two authorities is not true? It says examination. CR 30 is an examination, and none of the cases before the court says that it doesn't mean exactly what it says. And on those bases alone, Ms. Eyman should not be testifying in this case.
Mr. Newman, what lines of inquiry would the state explore on the deposition of Ms. Eyman that might not implicate Mr. Eyman? Are there any?
Well, Your Honor, I'm gonna lay out our outline in advance, but we raised this check issue specifically. So I don't know why Mr. Eyman's business associate is writing Mr. Eyman's wife a $13,000 check, and we're writing his children a $13,000 check. So I don't know if it's gonna implicate him or not, but they've taken the position that we can't take it even if it is favorable. Even if she said, oh, he's my godfather, that's why he gave me $13,000. They're saying, still you can't, because they said you can't testify for or against. So we don't get any explanation at all.
Okay, I'm ready to rule on this. This is an issue that, if not an issue of first impression, it's an issue that for which there is no clear answer, at least in the court's research. The court is convinced that a deposition is an examination. That being said, the court is not going to order that Ms. Eyman cannot be deposed. I apologize for that double negative. But any deposition of Ms. Eyman may not include inquiries that implicate Mr. Eyman, because the court is convinced that the spousal privilege rule precludes that examination. However, because it is unclear to the court for reasons that make sense to the court, as Mr. Newman advised, the state has no obligation in advance to tell anyone, including the court, what it intends to inquire of Ms. Eyman. That the state has the right to depose Ms. Eyman on any issues that are not protected by the spousal privilege. I understand that, or I fully expect that the parties will be back before this court, actually probably before the special master, on the issue of either most likely post-deposition issues of Ms. Eyman and whether Ms. Eyman should be ordered to answer questions. I'll leave it at that. What I'm trying to say is I'm confident that this ruling does not resolve the ultimate issue of what evidence, if any, Ms. Eyman may offer. Period.
Your Honor, can I ask a clarifying question?
Yes.
So, I agree with you, we're gonna end up back in this order talking about this again, but I'm wondering if you could give us more guidance on the types of questions that are allowable, and here's my concern.
I don't see it, taken at face value, I don't see any constitutional or statutory protection available to Mr. Eyman with respect to the inquiry of the checks. Did you receive these checks? What are they for? Those types of things. I mean, and Mr. Hensrud has probably thought this over in much more detail than the court has. And his opinion may differ from that of the court. But I'm disinclined to start making rulings right now on what questions can and what questions cannot be answered. There's always the issue of, I guess, interrogatories post deposition, where a court would have the ability to have those questions before it, or the special master, and to make a ruling, hear objections and make a ruling. I know that probably doesn't give you the guidance that you're seeking.
Well, it was helpful if we put it into the order that you are finding today, and this would help Judge Tabor out too if we end up in front of him, that we can examine Ms. Eyman about the checks that she and her children received and the background reasoning for those checks.
Mr. Hensrud?
Yeah, Your Honor, the whole problem with all of this, and the reason the testimonial privilege is absolute, is because your hypothetical depends on the answer. And you're never going to get the answer, because we can't give you the answer. So if we come back in front of the court and say, they asked that question and we assert the privilege, I can't even give you a hypothetical, but you could certainly envision one where that would implicate Mr. Eyman.
I can't. Well, the only one that I could envision would be Ms. Eyman testifying that she received that check as a conduit to
For
Mr.
example,
Eyman.
for example.
The flip side of that coin is, you cannot just assume that that's what her answer would be.
Right,
Maybe she has an answer that does not implicate Mr. Eyman.
For sure, and that's why I'm saying you can't prejudge the answer to that question before we, obviously, we object, we don't think she should be deposed at all, but you ruled, I'm not gonna go back there. But I don't think you should put in the order, she can answer these questions, because you just don't know that right now. And if you wanna say, go forward, find if there's ground available, go forward. I can't envision ground that is available. Obviously, I know the facts a lot better than you do, but I can't envision that. But I've been wrong before. Maybe there is some line of inquiry that could theoretically, be available in this. But I would caution not to say what she can't do.
Yeah, I will accept that caution and decline the invitation from Mr. Newman, because the court wants to be very careful in making rulings without knowing the facts of this case or what Ms. Eyman's testimony would be in response to a question in the form of a deposition. So the court's ruling is going to be limited to the motion to quash the subpoena is denied, the state may depose Ms. Eyman. If Ms. Eyman asserts or refuses or asserts privileges at her deposition, the special master and perhaps later the court will have to make rulings on all of those questions balanced against privileges and or privileges in the form of spousal privilege or constitutional privileges. That's as far as I'm going to go.
Thank you.
It might be an exercise in futility. I don't know. Okay, let's take up the other issue, which is Mr. Eyman's motion to revise the special master's order denying the motion to name confidentiality of documents and the alternative to amend the protective order to include documents from Mr. Eyman's computer.
Thank you, Your Honor. This is the one, and I mentioned it before, but I'll put it all in front of the court because it's been a few weeks since we've been in front of you. There was an initial motion about this that was a few hundred pages, and then shortly, actually before this court ruled on that motion, there was the subsequent order for 350,000 pages, which is why I suggested to the court last time, let's roll them into one and deal with it at once, which is what we're here for.
Yes, thank you for that.
Thank you. So, the documents are designated confidential. As this court's well aware, Mr. Eyman didn't have the funds to review all of them. He didn't. We tried to do some electronically based searches to weed out privileged and related kinds of things. But my office has never reviewed the entirety of the 350,000 documents that were taken from Tim Eyman's personal computer as a result of the ESI protocol. So that's where we stand. So what we did is we put the confidentiality designation on those documents, not knowing, admittedly, some are probably not, some probably are. And so what the state did in response is a blanket, none of them are confidential, which is what Judge Tabor ultimately bought off on, saying we can't do blanket, which I don't actually take issue with, to be honest. I don't think they can do blanket either. And you know, all of this for me kind of runs through the sort of trial lawyer part of this. We all know that 1,000 pages of these will ever be in front of the court in a deposition or otherwise. I mean, maybe not even that. So we're really talking, we're having this big fight about 349,000 pages that are never going to see the light of day. So I'm not even sure, frankly, why the state wants them to be all unredacted unless it is some sort of, continue putting them in the press releases as they go. But in terms of a litigation position, I'm not sure what it is because we're not there. So, but for me, it doesn't have to be all of the other. And that's not what I'm coming here to say. I'm not saying that this court should rule that all those documents are confidential. I can't do that in good faith because some of them may not be, and I'm prepared to accept that. But what I am asking the court is not to prejudge. We have given a number of examples to the discovery master and to you of documents that clearly would be confidential and should be treated as such. And I can't give you every single one of them, nor would I, if we went through every single one of them and Mr. Eyman had the money to do it and we found that it was, say, 12,000 pages. I'm not going to go to the referee with 12,000 pages and say, read through all of these and make sure every single one of them is confidential. So the better course of action, of course, is if there are documents that need to be used along the way for whatever reason, and the state believes that the confidentiality determination is burdensome.
Why do you say that? Why do you say that's the better course of action? Because then that shifts the burden to the state to do all of that legwork.
Not necessarily, Your Honor. I mean, they're going to review the documents, right? So they're going to come up with whatever documents. You know, let's say to me, I do this all the time. I mean, just about every protective order I enter into works that way. You have confidentiality, and then if someone wants to oppose the confidentiality, they go to the other side and say, here's these documents. And I'll tell you, maybe not every time I practice, but almost every time I practice, it's because you want to file it as a motion. And you don't want to go through the whole motion of unsealing it. And so you look at the document and say, this isn't really confidential, and you shoot them an email and you say, I'm going to file this, or, you know, these. They're not confidential. And 90% of the time we agree, and they move on. Some of the time we don't, and then we take it to the court. And that's what I'm proposing. I don't think there's necessarily a burden involved in that, Your Honor. But the alternative, I think, ignores the reality of this situation. I mean, it ignores the fact that some of them are confidential. I mean, even the state's opposition conceded that. And we've given other examples that aren't conceded that we think are clearly confidentiality. You know, information about Tim Eyman's minor children. How could that ever be a good idea to put their schedules and their sports teams and stuff in the public record? I can't envision that. So we know that some of them are. So the only question is, how do we deal with that? I agree that a blanket, they're all confidential, is not appropriate, but nor is a blanket, none of them are confidential, appropriate. I think what should happen is they should be treated as under the protective order until the state wants to use them for whatever reason, or even they don't want to use it, they just want it to be done, and they send it to my office. If it's not confidential, we're very reasonable, we'll say that. If we think it is confidential, then we'll have to take that specific document in front of you or Judge Tabor. And you know, that, I think, allows everyone to get where they need to go without ignoring the fact that these documents have substantial confidentiality. And part of Judge Tabor's hang-up with that, as you can see from his order, is that he didn't feel comfortable. He thought, in dicta, I think were his words, that your protective order could be applied to documents other than the financial records. We agree, why would we keep entering protective orders? But he didn't want to do that because he thought that would be sort of like him amending your order. And so that's kind of part of it, is I think for the court to say, yes, the confidentiality can relate to those documents. I think it's just something like that, or designated in good faith belief or something, I think were the words of the court in that regard. That's part one. And then part two is, how do we deal with this going forward? And our proposal, what we've always said, is it doesn't need to be blanket, but we should deal with specific documents as they come up, if they matter. Because like I said, 349,000 pages of these aren't going to matter. So why waive significant rights that Mr. Eyman has that we know exist because they've been conceded, simply because he can't afford to go through each and every one. But even if he could, what would we do? I'm not going to bring 12,000 pages in front of here, in front of the court, and ask you to review each one. It doesn't make sense, not only for the court's time, or Judge Tabor's time for that matter, but for the reality of the situation. Because if they're going to sit there on some hard drive somewhere with confidentiality protection, and a state employee is going to click through them once and never look at them again, why should we come here and waste time having that fight? I think what we should do, Your Honor, is make sure that it's clear to Judge Tabor that the protective order can apply outside the banking and financial records, and then make clear that no side wins here, but that confidentiality of documents will be determined on a case-by-case basis if necessary, and if the parties meet and confer first. And that, I think, Your Honor, is a common sense solution that allows everyone what they need to continue with this litigation, but doesn't waive anyone's significant confidential rights, which I think we've proved.
Thank you. Ms. Dalton?
Good morning, Your Honor.
Good morning.
Linda Dalton, representing the state of Washington on this matter. You can probably anticipate my response to all of this. Mr. Hensrud tries to come off very practical, very reasonable, and quite frankly, the only reason we're here is because what the state has received in discovery has not been reasonable. We wouldn't be here actually, but for the fact that the Eyman defendants chose a path to respond to discovery, and that was to not review 350,000 pages worth of records and then push that burden to the state.
Say that to me again, because I was distracted a little bit through
Sure.
no fault of your own.
Sure, no worries. They chose a path in responding to discovery, where they took the search terms that the special master in this court agreed to, applied those to documents that had been in their possession. The hard drive was imaged back in January, and then waited till June in order to try to respond to this court's decision that they would have until the end of July, early part of August, to provide the responsive documents. What they chose to do, and while it sounds very reasonable when you talk about what normally happens with protective orders, the other thing that normally happens when you're dealing with protective orders is the fact that the other side has gone through and reviewed things for responsiveness and then provided them. That didn't happen here. What they did is they took everything that was responsive to the search terms and pushed that to the state.
Hence my question to Mr. Hendricks.
Exactly.
It appears as if there's kind of a shifting of the
Absolutely.
burden and from a non-legal perspective, that the shifting of the workload, I guess.
Absolutely. That's exactly the position here. And what they don't provide you in making that argument is any case law, any citation, any authority that allows the receiving party to be responsible for that burden. The burden actually does reside with the producing party. So what they should have done is start producing records when they originally got the records request back in June of 2017, when started reviewing them in January when the computer was imaged.
Would there be anything that precludes the defendants from going through those documents now and advising the state that they consider certain documents to be confidential and having that discussion with the state?
Or designating them
Or
as such?
designating them as such?
No,
Okay.
no. And what we have at this point is, there's two burdens going on here. First is the burden that they have to show that the special master got it wrong, that he in fact wasn't holding them to what is their burden when you want a protective order. You have to be able to show not only the good faith, reasonable basis, but a legal basis with which a protective order should apply. And what they told you is they don't have that with respect to everything they produce. They haven't even looked at it all. So they can't even meet it, even if you were to agree that the existing protective order applies, the provision in there, they haven't met that either. So with respect to their burden of showing why the special master got it wrong, they haven't met that. They haven't met their burden of showing that all of these records would be in fact subject to either the existing protective order or a different protective order. All of that burden lies with them. And because of the way they chose to address their discovery responsibilities, they're in the situation that they're in. State didn't put them there, the court didn't put them there. They made choices along the way, and that's what put them where they're at. And so what you have here is an argument designed to try to get them out of that box, but they do so by pushing the burden to the state, that the state is responsible for going through all of these records, and there's almost 60,000 documents themselves, go through all of those records, decide what it believes to be non-confidential, and then go through the process. You're pushing the financial burden, you're pushing the time burden, everything that they should have taken responsibility for at the outset. And this would not be happening because, as Mr. Hensford said, normal course is you have some discussions after you receive the documents to determine how they're going to be used. And it's not just in litigation, and it's not just in summary judgment, it's also during discovery, which we are in our window now of completing. And so understanding that if they're going to be provided time to continue going through and making these designations, that's time that's being eaten up in the discovery time. So with respect to whether they in fact met their burden before the special master, they didn't. He found that they didn't. They don't give you anything to suggest that he made some error of law.
In fact, as I understand Judge Tabor's thought process, it in part was, there's nothing here in front of me. How can I determine whether it is confidential or not? It would be both impractical and unwise to just make a blanket decision that all of the documents at issue are confidential, because I don't know what they are.
That's correct, because in the first instance, they gave him 952 pages. I can tell you, because I looked at all of them, probably 200 of them are 4 emails. And 47 pages per email, the first 45 of them being blacked out email addresses, page after page after page. And then when he actually looked at some of those, he found that they were directed to the media. And so he did make a determination with the second order that any confidentiality you might have had would have been waived if you're giving these to the media, which is the right answer, and they don't dispute that that's the right answer. So what you have here is a situation in which the second time they came to him, they gave him 18 documents, 409 pages, And still from those, it wasn't like a situation where they gave him, okay, we have categories of documents. These are all the emails we have, 1,000 pages of emails that are discussions of the kids' soccer schedule. One has to question first, they got them, why they gave them, turned them over in the first place. But that would be a category. We want those to be confidential, they have nothing to do with this, and the state would agree that there's nothing in those that bears any resemblance to responsiveness to the discovery requests. And then you have this level, there wasn't even sort of a systematic approach to helping the special master or this court now look at how to characterize any of this. And because they're not taking responsibility for it. They want the state to have the cost, the responsibility. And in their reply brief, they talk about that this is the fair thing to do. This is only fair. It's no harm to the state. And in this case, I would put it to you, yes, there is. 350,000 pages of records to go through, and we have started, and we are going through them. And we're finding, as the declaration said, 40% of them are duplicative. You'll come to an email, and then you'll come to the next email is the same thing, the next email is the same thing. So they didn't even weed out all the duplicates. But that is a burden that's now on the state, when the burden is supposed to be theirs, and they should have done this. So we don't believe that the special master, based on the law that he had before him, based on the documents he had before him, did anything that was an error that requires revision. I understand they're in a difficult place, but it's one that they made, and it's one of their choosing. And so we're asking you to honor the special master's decision in both instances, both the first order and the second order. The second order encompasses all the records. The first one is just a small finite group. We're also asking you to determine that the existing protective order is limited to what it was put to you and what was requested from you and what you signed that had to do with financial records and tax records.
Why is that? Why would the state object to the protective order being extended to protect personal emails from Mr. Eyman to coaches, his children's coaches, birthday greetings that are not sent to or CC'd to business associates, those types of communications?
A couple of reasons. First, you haven't been presented that information. That information wasn't presented to the special master in that way either.
But what's the downside in expanding the language in the protective order so as to potentially protect those types of documents?
Purely personal.
Okay.
Yeah. We would have no objection.
Okay.
Had we been asked about it, we probably would have had no objection. We didn't ask for them,
Okay.
so we didn't expect to get any.
But it appears as if perhaps, I don't know what the state received, obviously, but perhaps the state did receive some such documents.
Yes, I have reviewed
Okay.
soccer schedules. But what I would caution against is things that are labeled as personal, that in
Understood.
fact are not. The
Right.
two documents that you have, the quote Christmas greetings,
Right.
you can take out the first couple of sentences and it looks like just every other two-page solicitation for contributions to political committees. So that would be the line we'd have to be very careful about drawing for that.
And perhaps that might be an issue that the special master, maybe ultimately the court has to decide on, whether they are purely personal or not, or a hybrid thereof.
Right. Right. But that would be a matter then to take back to the special master. He didn't do anything wrong in this regard, and so his order should stand. So unless you have other questions, okay.
Thank you.
Thank you.
Mr. Hinter.
Thank you. First, I have to distinguish the workload issue. There's a big difference here between who's reviewing the documents and who has the duty at the end of the day to show confidentiality. I accept the latter duty, right? If we're going to say something's confidential, I do think we have the duty to show that it's confidential when it comes in front of the court or the discovery master. We can set that aside. But review of the documents has nothing to do with that, though. This is sort of a backdoor of trying to punish us for giving the documents, and I'll talk about that part in a second. But if you're asking me as an attorney, hey, do you want to go into trial with 350,000 pages you've never reviewed, or do you want to go ahead and review them? This is not strategy, Your Honor. No sane attorney would say, yeah, let's just go ahead and turn them over and see what happens. We couldn't afford it. That's why it's there. That's obvious. And the reason, the second part of this is the timeline. It's true that we imaged that his entire hard drive. We had a third-party vendor who has credentials to take custody and do that before we were ordered to do so. That was one of the first things I did in this case when I got it, was let's get that done, let's get it segregated, and then we'll go. And that's how this works. So you ask a discovery response, but if the discovery response calls for ESI, you sit down and you figure out ESI search terms. I don't want to say never, just about never, go through a file of this size before I've agreed with opposing counsel about what is going to be produced out of it, because then I'm going to end up doing it twice. So that's what happened during that time frame. We had a discussion back and forth. We thought their search terms were too broad. We lost. But exactly that, what we said would happen, happened, right? Now we've got 350,000 pages and we can't afford to review it. That's what we were saying for months. Great. Now here we are. I'm not coming back to re-argue that, but I also don't think we should be punished for exactly what happened when we said that's what's going to happen. And so if they have to review the documents, great. I mean, in our relativity database that we use to review documents, it's literally a check mark if you want to put confidential or not confidential. There's no burden on them for doing so. Not to mention, you know, they're saying we shouldn't have to go through the documents. Well, if you don't want to go through the documents, then none of us care, because the documents are never going to see the light of day. So why would you go through this process? Why would we even be having this discussion? But of course, Ms. Dalton later said they are going to go through every single document. And at that point, obviously, you know, these discussions can be had. And so that I think is the critical distinction between workload. There's a difference between us having an obligation to review the documents that were yielded based on their search terms, and us having a duty to prove confidentiality. I accept the latter. I do not accept the former. What happens is exactly what we said was going to happen, which I think is, well, I don't want to re-argue that. That's what happened, Your Honor. So that's where we are. You know, with respect to not, you know, having the duty to demonstrate confidentiality, the first 900 pages, Judge Tabor said he didn't review any of them. We put them all in front of him, but he said he started to click it and it looked like it was going to take too long to download, and he didn't even download them. So we can't say that we didn't put things in front of him to talk about these issues. We have, and we did. We put more in front of you, that's true, because we keep finding them as we go along here, as we do searches to try to get documents. And that's what I think is going to keep happening in this case. They'll find something, we'll find something, it'll clearly be confidential. So I think removing the confidentiality protections at this point doesn't make sense. I think it makes a lot more sense because once the rabbit is out of the hat, you can't put it back in, to leave things as they are. This court doesn't have to determine they're confidential. I'm not asking you to do that. But I am asking, meet and confer before we go forward with those kinds of documents. If there's a specific document that becomes an issue, that we disagree on confidentiality, we take that document from Judge Tabor, which I'm sure he'll read if he has a single document in front of him, and we'll do it that way. Otherwise, we're asking about categories. You've identified one that we think is crystal clear, that there are others. But I do think it's unfair for this court, and I do think it's unfair for Judge Tabor to classify as confidential documents that they've never reviewed. But the flip side is also true. You can't say they're not confidential if you've never reviewed them. So all we're asking is that the court respect the reality of the situation. You could say we contributed or not to how we got to the 350,000 pages we weren't able to review. But the reality of the situation is that's where we are. The reality of the situation is we haven't reviewed them, and the reality of the situation is that some of them are confidential. And once they go out to the press in a press release or, you know, a public records release, we're never getting them back.
What about that instance, Ms. Dalton? What Mr. Henford raises a good point, and he made that in his pleadings in support of his client's motion. That if the documents are not confidential, they are, as a matter of law, susceptible to a public records request without prior notification to Mr. Eyman.
The state would be willing to provide notification without an order. All they had to ever do was ask.
Okay.
Because the statute allows for notification to be provided under the Public Records Act, and the state would be happy to do that when we receive a request.
Okay. I apologize for that.
No, Your Honor, and that's obviously one of the issues. I mean, what they're saying is not far from I mean, it may be almost identical to, with the exception of using it in this case to file it first. That's all we're asking, is before, something goes public, just let us know what that document is, and we will accept the burden of confidentiality if we disagree. So if we're gonna do that document and we say, you're right, it's not confidential, which is usually what we say in these cases, we can usually agree. I don't wanna take that too far in this case, but usually, if not, then let's take that document, we'll accept the burden that we have to show that it's confidential, that we have to show it's confidential, and if we fail, so be it. But that's all we're asking.
The court denies the motion. The court believes that it would be unfair to essentially shift the burden, the workload burden to the state. The order in effect will remain in effect. The court is amenable to, or the court will amend or enter a separate protection order that would allow for documents to be classified as confidential if they are communications that are, and I'm struggling to find the right word, and I'm not certain I can find the right word, but the intention of the court would be to protect clearly personal email communications between Mr. Eyman and family members. I hesitate to use the word close friends because Mr. Eyman no doubt has close friends who are contributors. I don't mean that in a derogatory way, in fact, just the opposite. But the court believes that the protective order should be amended so as to allow for certain documents other than purely financial documents, unrelated financial documents to be confidential. And the court is hopeful that the parties, if not today, but at some point in the relatively near future, agree on terms that might be included either in an amended protection order, in an amended protection order. It will be the ruling of the court that the court will extend the protection order so as to protect communications between Mr. Eyman and certain communications between Mr. Eyman and family members, as opposed to the protection order that is currently in place, which relates only to, as I recall, financial documents. I'm hoping the parties can talk about that. So
We can, yes.
I understand they'll probably require some time for the parties to get together and propose orders that reflect the court's ruling this morning. You can do that now if you want, because I'm going to be off the bench, or you can do it later and present orders.
I'd prefer to write them up and.
Okay.
Yeah, because I think it'll take just to go through the existing protective order and just make tweaks to the scope section.
Okay.
Do you want to start or me?
The
I
court
would be
will,
happy to start.
Okay.
The court will, I was going to ask to go off the record and then thank the parties, but the court believes it's also appropriate to thank the parties while we're on the record. This is a case that involves diametrically opposed interests. I understand that. I understand that Mr. Eyman is concerned about the privacy of, not just his personal privacy, but the privacy of his family. He has a right to have those concerns. And he has a right to have the court respect those concerns. The flip side, of course, is the right of the government to conduct discovery, appropriate discovery, in support of its claim against Mr. Eyman and the other defendants, and there's a delicate balance between the two. The court is doing its best to recognize the interests of the parties and apply the law to those interests and to those facts. And against that backdrop, all parties in this case, including the parties who are not present in court this morning, have conducted themselves, at least in court, because I'm not around these lawyers outside of court, but have conducted themselves in court very professionally, very cordially. I appreciate that. Thank you. Let's go on to it.
Thank you.
Thank you.